least circulate the recording, it sounds a bit neater. So really the purpose of these webinars is to recognize that South Africa is not an island in the international community. We do get affected by international events and goings on, but also we can react and lead through our ideas and our actions to those international events. And in today's topic, international mechanisms for anti-corruption, I think we have a very poignant contribution to make with a really excellent panel. And what I'm going to do now is just introduce the panel by name and designation in the order that they'll speak, and I'll hand over to our facilitator after that. And that's Prosper Maguchu from the University of Amsterdam. Then we've got Michael Marchant from Open Secrets, where he's the head of investigations. And we've got former Constitutional Court Judge Richard Goldstone, who's now the Vice Chair of Integrity Initiatives at the University of Stellenbosch. And then Prof. Firoz Cachalia, who's the Director of the Mandela Institute at WITS, and also the Chairperson of the National Anti-Corruption Advisory Council. So, Prof. Maguchu, over to you.
Thank you very much, Chris, and also on behalf of the Helen Suzman Foundation for offering a platform to discuss such a timely and relevant topic on how to harness international mechanisms to fight or win the war against corruption. Before I came in here, somebody sent a private message to me asking, so what does corruption in matter one that does not even in some other states statutory books, why does it have to be elevated to an international level? That I thought, oh, that's a very fair question. And I've been pondering and thinking about it. And I said, well, perhaps maybe the most fairest answer to this question is that it is now widely accepted that corruption is a transnational crime. So the crime of corruption does not have any respect for political or geographic boundaries. It crosses national borders. Corruption in South Africa can have a negative impact or ramifications in other countries too. But at the same time, is corruption an international crime, at par with international crimes such as the crime of aggression, war crimes, genocide, etc.? Maybe this is the topic that a colleague here, Richard Goldstone, will answer, but I think I'm already ahead of myself. Before we even go to the point to discuss the international, I want us to come back again, maybe to the uninitiated, those who may be joining the talks for the very first time, or who are new to the topic on corruption and international mechanisms, to be on the same level. In the next 15 minutes, I will invite Michael to give us a brief background of the, corruption in South Africa, and perhaps also even, delve a little bit or divert also into the international, or rather the transnational aspect of corruption in South Africa. So Michael, you have 15 minutes. Thank you.
Thank you so much, Prof. And thank you very much to the Helen Suzman Foundation for the invitation to be online today. Prof, it's funny the way you started, because I think that I asked myself the same question, which was, preparing for this and asking, well, the cross-border nature of corruption. There's actually quite a few different elements there, I think, in different typologies and different ways in which transnational corruption really manifests. And so what I wanted to do in the time available to me today, and I will try and be very disciplined in terms of that time, is to speak about, I think, three kind of key ways in which the transnational cross-border nature of corruption has manifested in South Africa in more recent years in particular. And kind of breaking it up. And in each of those cases, I'm going to try and provide some concrete examples that help us anchor the conversation in some cases that hopefully we either know about in detail or at least know about in passing, so that we can kind of use those examples, hopefully, for the concrete discussions later on. Given the time that's available to us, I might move quite quickly through some of those examples, and apologies if I do gloss over some of the forensic detail, but I know that there will be opportunities for questions at the end, and so we can engage in those things. So I think as a starting point, perhaps the obvious entry point in terms of the cross-border nature of corruption is the extensive role of multinational corporations based in different parts of the world in the basic form of bribery and their role in corruption. And I think in contemporary versions or contemporary iterations of state capture in South Africa, there are a few very clear examples of that. And they're numerous, and they're not linked to one geographic profile. And so we have large corporations headquartered in the United States, in various parts of the European Union, in Russia, in China and other places, engaging knowingly in either suspicious payments or bribery linked to corruption in South Africa. There's one, I think, very helpful example of this, which paints some of the difficulty of dealing with cross-border corruption. And that's the role of the German headquartered firm and its Spanish subsidiary, Fossler España, in the famous Prosper corruption in South Africa. So for South African listeners, you might be familiar with a now very infamous story of the nearly 3 billion rand that the passenger rail agency spent on trains that were far too tall for South Africa's railways. And that, I think, contributed to a great extent to the kind of destruction of passenger rail in South Africa. Now, the company that was contracted by Prosper to deliver on those trains was a German rail company, Fossler, and in particular, its Spanish subsidiary. And that company paid, I think, knowing that the specification of the trains was wrong, it paid hundreds of millions of rands to its what it would call agents in South Africa to facilitate the transaction between Prosper and Fossler. So we know, for example, in particular, that Fossler paid around 90 million rand to an individual by the name of Mackenzie Mabunda. And it was quite famously reported after that that Mabunda spent some of that money on a kitchen, a luxury kitchen for his home. But when multinational corporations pay agents to bring them together with state-owned companies, that's a kind of large red flag for corruption. It's a common method used by, for example, international arms companies and other corporations engaged in corruption. The difficulty, I think, in this case, and why it's a good example to use, is that pursuing accountability in this case across borders has been incredibly difficult. So South African activists and civil society organizations, for example, have tried to engage German authorities, who largely have kind of fobbed them off and said the Germans can't act until the South Africans get their act together. We know that Spanish law enforcement are investigating this and have requested South Africa's law enforcement to engage in mutual legal assistance with them. But of course, there's very little public information about how that request was responded to by South African authorities. And then when we come to the National Prosecuting Authority, although this case has been in the public domain for around about kind of 10 years at this point, we don't have any significant prosecution that has been instigated in this case. We have one conviction of Daniel Mthimkhulu for faking his qualifications, pretending he was an engineer at Prosper. But we don't have any completed charges or prosecution against the individuals who are involved in the actual tender corruption, which would require in this case to understand the flow of money, as I've said, from at least Spain and certainly possibly from Germany as well. So I think Prosper is a good example of this. Just to mention quite briefly, other examples of global headquartered firms involved in bribery would be around Transnet. So Transnet was in monetary terms, was the single largest site of contemporary state capture in South Africa. It's estimated that about 40 billion rand was lost to procurement corruption at Transnet. And that was largely around a few very large procurement contracts that were deliberately inflated to procure locomotives, the famous 1,064 locomotives for Transnet's rail. And again, in that case, you have in Chinese state-owned rail companies at that time, China North Rail and China South Rail, apparently knowingly paying inflated prices to Transnet, so the Transnet could then pay that money on in kickbacks to various members of the Gupta family and various companies linked to the Gupta network. Those Chinese state-owned rail companies are currently embroiled in ongoing legal disputes with SARS in South Africa, who managed to freeze some of those funds before they could remove them from the jurisdiction. And in that case, the MPA has brought a prosecution against various individuals that were involved, but it is yet to proceed. So that matter is yet to go to trial. And then in the case of Eskom, a number of international firms have been implicated in bribery and corruption there. Prior to contemporary state capture, there's the famous case of Hitachi, but more recently, T-Systems, the German firm SAP. And in terms of where there has been some limited accountability, the Swiss firm ABB that paid a 5 billion rand settlement to Eskom that was negotiated between South African, United States, Swiss, and German authorities. So we've got that kind of part of the story, that international firms, multinationals engage in bribery, and that inevitably involves the cross-border flow of funds and implicates law enforcement in different jurisdictions and makes it challenging to deal with. On the other side of that story, and this is the second kind of really important part of the cross-border nature, is for those, for example, in South Africa who are implicated in the corruption, where do they hide the proceeds of crime? And, you know, it is no accident that the Gupta family and those linked to them favored Dubai in particular as a jurisdiction to stash money, to buy cars, to buy property, and of course, ultimately to flee when they feared arrest. And that, you know, that ultimately proved to be a successful strategy because they were not extradited. And I think many of us know the story of the failed extradition proceedings in the UAE. But I think to take a step back and to go back to how they got that money out in many instances, we really need to remember that there is an international financial architecture now that is run by international banks and a range of professionals, from company formation agents to auditors, lawyers, consultants, and accountants, who really base their business on assisting individuals to hide their ownership, for example, but also to move money across borders in order to hide the proceeds of corruption. To use an example I've already given so that we're not using too many different examples, Transnet corruption is a fantastic example of this. We know of some instances, for example, that in the Transnet deal, China South Rail paid at one point more than 5 billion rand in transactions to 2 Hong Kong front companies, Regiments Asia and Tequesta. Those companies were registered, and within months they were receiving billions of rand in transactions from a Chinese state-owned rail company, despite no prior operations. And those companies then immediately dissipated the funds to a range of further front companies, both in Hong Kong, but also in China. HSBC held all of those bank accounts and facilitated those transactions, HSBC being, you know, one of the largest global banks. And we and others, you know, before the Zondo Commission and state capture have argued that HSBC ignored a series of very obvious red flags for corruption. So when it comes to money laundering, there are a few things to look out for if you think about them. So for example, a very young company with no trading record receiving extraordinary amounts of money, that's one red flag. Any company that immediately dissipates funds that it's received without keeping any trading balance. Paying those monies out to firms that have no apparent link to the contract in terms of which the payment has been made. And of course, in that case, the companies and their bank accounts were registered by Salim Essa, who, if anyone at the bank had undertaken any due diligence at the time, would have known, because at that time it was already in the South African press, had been linked to corruption. Why that's important, not only because of the role that those banks and other, you know, individuals played in money kind of going out, but also because it makes the retrieval and recovery of assets so difficult. You know, I think one of the defining features of state capture in South Africa is that we have largely not been particularly successful in recovering the funds, particularly that have found their way into assets in different parts of the world. But that's because the international system makes that so difficult. And if you can successfully launder your funds and break the trail for law enforcement, it becomes incredibly tricky. And we know, for example, from statements from the National Prosecuting Authority and others have essentially said that authorities in the UAE and their financial systems do not want to provide the type of assistance they would need to trace funds, identify them, and recoup them. And so the money laundering side of the story also becomes hugely important in that regard. I know that I'm a little bit tight for time, so I won't discuss this example in any detail, but another important example of this for those who are interested is that the now infamous Gupta wedding at Sun City, part of that was paid for with the proceeds of the Estina dairy farm scandal in the Free State. That money left South Africa, went into Dubai, and was laundered back into South Africa to pay for the expenses for that wedding. And we now know, given investigations by law enforcement and the auditing authorities, that the Guptas did that with the help of auditors at KPMG, who were implicated in various instances of state capture, and that one as well. So we've got the role of foreign companies and multinationals in bribery, and we've got the role of professionals, banks, auditors, accountants, others in the kind of financial architecture that allows the flow of funds and the hiding of assets. A lot of those examples come from state capture. In the last minute or two that I have, the final kind of element of the story that I wanted to tell is that when we speak about state capture, we speak a lot about the role of foreign multinationals in our capture and the way South Africans dissipated money elsewhere. But there's also a growing trend, and I think this should be very concerning to South Africans, of South Africa's financial system being used to launder the proceeds of corruption from elsewhere in the world, and particularly elsewhere on the African continent. And so we've worked together with other organizations on a series of investigations, for example, that have showed that individuals very close to Emmerson Mnangagwa, the current president of Zimbabwe, have used South African front companies to funnel public funds from Zimbabwe, including money that has been paid out by the Zimbabwean Reserve Bank, via and through South African companies, through South Africa's financial system, and in many instances then out through Mauritius, and ultimately to the United Kingdom, in some instances to externalize those funds. That is possible partly because South Africa's financial system has been porous. We know that we are on the grey list because of systemic deficiencies in the way we identify and stop illicit financial flows in South Africa's system. But also because we still do not have full transparency in company ownership in South Africa, which allows foreign politically involved individuals to use the system in that way. We also had a story just a few months ago now where the Zimbabwean Electoral Commission has been embroiled in a corruption scandal. And we know, for example, that a lot of that money came to a South African-based firm that then paid the money back to agents based in Zimbabwe that then allegedly paid that money on as kickbacks. And just as a passing reference, we know from the Al Jazeera gold smuggling documentary that there is a huge amount of illicit financial flows that link Zimbabwe, South Africa, and the UAE when it comes to gold transfers. So South Africa as a possible hub for dirty cash is that third and final kind of component of cross-border corruption that I wanted to mention. In my very final line, and Prof, I will now go back to you, I promise, which is just to say that there is, I think, an underlying question here, which is maybe interesting for everything that will flow the discussion now in terms of how we deal with this, is that there's an underlying problem of a lack of skill and capacity within South Africa law enforcement to deal with these issues, which has raised the issue that many of these things have continued with impunity, that we have not seen adequate accountability for any of the private actors that have been involved in these types of activities, which really does kind of make urgent the discussion about how, possible alternative mechanisms to pursue that accountability. Thanks.
Thank you very much, Michael. That's indeed a very transitional question. Perhaps we would then have Justice Goldstone to take over from that. But before that, just allow me to make this comment, Michael, rather. This was quite interesting. First of all, breaking down corruption into its different elements. Always important whenever you're having a discussion about corruption, of course, to discuss which, or if at least to distinguish which types of corruption we're talking about. So you highlighted some very illuminating yet also depressing examples of bribery in South Africa, its transnational nature, both in terms of the source of bribery. You know, the bribes are coming from states that otherwise appears to be very clean if we look at the widely circulated corruption perceptions index, like the Transparency International Corruption Perceptions Index. Performance is quite good, but at the same time, this is the source of bribery, bribes that are being paid into developing so-called developing states. Again, another important point why we need to have an international mechanism. But also, you highlighted something also quite interesting about professional money launderers. Those who assist money laundering, who assist unscrupulous politicians, senior public officials to launder their ill-gotten gains and facilitate corruption, be it at a national or transnational level. I think we'll come back perhaps when we open the floor for the audience to ask questions or any clarification. But I want us to carry over the conversation from where we left, the need for alternative mechanisms. Obviously, it's quite clear now, despite glaring evidence that there has been corruption at the local level, at the national level, there is not so much enthusiasm to address this type of corruption, especially corruption at the grant level, corruption involving senior politicians or public officials. What ought to give? Maybe, Richard, in the next 15 minutes, you can also perhaps carry over with this discussion. Thank you.
Well, thank you. I would like to add my thanks to the Helen Suzman Foundation for arranging this panel and for inviting me to participate in it. If I could start with a couple of numbers. Global Financial Integrity, GFI, is a Washington, D.C.-based think tank focused on illicit financial flows, corruption, illicit trade, and money laundering. GFI estimates that the annual value of trade-related illicit financial flows in and out of developing countries has amounted to, on average, about 20% of the value of their total trade with advanced economies. 20%, we're talking about huge numbers. According to the Economic Development in Africa report of 2020 by UNCTAD, the United Nations Conference on Trade and Development, Africa loses annually in illicit financial flows about 88.6 billion United States dollars, or 3.7% of its gross domestic product. So these numbers really trip off our lips, and they're beyond the imagination of most people, and certainly that is my approach to it. The lion's share of those funds are lost by reason of grand corruption or kleptocracy, the theft of public funds for personal use by our country's leaders, heads of state and senior cabinet ministers, and those who conspire with them. It is, of course, a worldwide phenomenon and regrettably all too common on our own African continent. We know only too well, and Michael Marchant has given us some graphic examples, we know only too well that in our own country, many billions of rands have been lost to what is really euphemistically called state capture. The huge sums lost to corruption each year, and this is the important point, deprive millions of people in many countries of their fundamental human rights, their rights to sustainable development, to be free of hunger, to have adequate education, and to live in society that encourages equality and equal opportunity to a healthy and satisfying life. Corruption undermines the very fabric of our societies, and of course affects mostly the women and children in our societies. So how does one begin to remedy this grave situation? There can be no question that independent domestic institutions are able to play a crucial role in deterring these illicit financial flows, and in some cases lead to their recovery. At the same time, we know that domestic institutions are simply not sufficient. The need to seize, freeze, and repatriate illicit assets is an international problem, and by no means only in Africa. Those funds are laundered in many countries around the world. As one illustration, in June of this year, it was disclosed that since 2019, Singapore has seized $4.4 billion in laundered funds, and that is probably the tip of the iceberg. Now, grand corruption does not exist because of a lack of anti-corruption laws. Indeed not. Most of the 186 UN member states that are parties to UNCAC, the United Nations Convention Against Corruption, have enacted the required statutes criminalizing bribery, money laundering, and the misappropriation of national resources. However, some states that are parties to UNCAC are governed by kleptocrats who enjoy impunity in the countries they rule because they control the police, the prosecutors, and the courts. And regrettably, some of those authorities themselves are often also corrupt. Those kleptocrats will not permit honest, effective investigation of themselves or their criminal collaborators. And we must not forget the criminal co-conspirators around the world, again referred to by Michael Marchant, the banks, the law firms, real estate agencies, and other financial service providers who aid and abet kleptocrats in the transnational crime of money laundering. Now, we know the International Criminal Court, the ICC, has no jurisdiction over the crime of corruption. And to amend the Rome Statute to include it is just not really practical or feasible. It would be politically fraught and more than time-consuming. I would add, too, that the International Criminal Court does not have investigators or prosecutors experienced in corruption and money laundering. It does not have the mechanisms that are able to seize and freeze illicit funds. It is in this context that there is an urgent need for the International Anti-Corruption Court, as we call it, the IAC Court. Such a court would have jurisdiction over crimes committed by nationals of an IAC Court member state and crimes committed in the territory of a member state. It would have no need to invent any new crimes of corruption, and I refer here to Professor Maguchu's original question about what is corruption, and particularly in the international community. An IAC court would rely on those mandatory crimes already recognized by the 186 states that have ratified UNCAC. So it's almost, these crimes have really been universalized and internationalized. They include the bribery of public officials, embezzlement, and other misappropriation of public funds, money laundering, and obstruction of justice in relation to those offenses. These have now become international crimes. The IAC court would be a court of last resort. This means that it would acquire jurisdiction only in cases in which the appropriate domestic authorities are unable or unwilling to investigate or prosecute the corruption. Member states would also be able to refer cases to the court. Such a court would have a huge advantage that the ICC lacks: jurisdiction acquired by the existence within member states of laundered assets. Those assets in any member state of the International Anti-Corruption Court would allow the court to prosecute the leaders who laundered those funds, and importantly, the power to freeze and seize those assets. And of course, there are no kleptocrats who keep the ill-gotten gains at home, for obvious reasons. Billions of dollars of stolen assets have been laundered in a number of countries. They include the United Arab Emirates, the Netherlands, Singapore, Switzerland, the United States, the United Kingdom and its overseas territories, the Cayman Islands. There are a number of others. If some of the countries where the laundered funds are held would join such a court, and several are considering doing so, then illicit assets could be identified and frozen by the court. Through orders of restitution, those funds could be repatriated at an appropriate time to the countries from which they were stolen. Now, Integrity Initiatives International, or III as we call it, of which I'm the vice chair, is a Boston-based international non-governmental organization and is presently drafting a treaty for the establishment of the IAC Court. Of course, such a treaty would have to be agreed by governments. However, it is our belief that a draft treaty would be a practical and effective tool with which to encourage governments to become engaged and involved and to discuss the project. We hope to have a draft treaty available by the end of this year. It is our intention to use it for targeted consultations with key governments and leading civil society organizations, both domestic and international. Those consultations will further refine the draft. It is then proposed to use the product as a call to action by the international community. I hope that the Helen Suzman Foundation will participate in this endeavor. Our drafting committee is fortunate to have as members leading experts on relevant international criminal law from around the world, many of them from the African countries. Our meetings have been hosted generously by a German foundation, the New Institute Foundation in Hamburg. We have met there 3 times since the middle of 2023. Our most recent meeting was held there at the end of August, about 3 weeks ago. At our most recent Hamburg meeting, we agreed to incorporate some novel provisions in the draft treaty. Let me mention just 3 of them. One is that the court should have 2 divisions. There should be a trial division and an assets division. The trial division would have criminal jurisdiction over the kleptocrats and other high officials who have plundered their countries and those complicit with them, those who facilitate the plunder and the laundering of the stolen assets. It would also have authority to freeze and seize the laundered stolen assets. The assets division, on the other hand, would settle disputes concerning those assets, whether at the instance of governments or private citizens. It would also hold the assets until they can be returned to the real owners, the people of the countries from which they have been plundered. Unlike the case with regard to other international criminal courts, the draft treaty will recognize juristic persons, corporations, as amenable to the jurisdiction of the court. This is regarded as crucial, having regard, for example, to the role played by corporations in the laundering of assets. Money launderers for many years have made use of shell companies to hide their ill-gotten gains. The third innovation I'd refer to relates to whistleblowers. In the first place, the treaty will prioritize protection for whistleblowers. They are really the most important source of information with regard to corruption. They are also the most vulnerable to attacks on their very lives and the lives of their families. Provision will also be made to remunerate whistleblowers who provide the court with original information not otherwise ascertainable. The jurists, lawyers, scholars, and anti-corruption experts working on the draft treaty come from a number of countries, including Trinidad and Tobago, Nigeria, Brazil, Cameroon, Bangladesh, South Africa, and Mexico, as well as the United States, Canada, Australia, and New Zealand. There are now over 300 leading figures from across the world, including more than 50 former presidents and prime ministers and 32 Nobel laureates, who have signed a declaration calling for the creation of the International Anti-Corruption Court. Colombia was the first country to call for such a court back in 2016. More recently, the Netherlands, Canada, Nigeria, Moldova, and Ecuador have committed to working towards the creation of the court. In January of 2023, the European Parliament passed a resolution calling for the International Anti-Corruption Court. Additional countries from each region of the world have also expressed their interest in the idea. The United Kingdom Foreign Minister David Lammy has stated that he supports the IAC Court. There were positive responses in the House of Lords at the beginning of last month when Lord Peter Hain asked the Undersecretary in the Foreign Office, Baroness Chapman, whether the UK government was in contact with other states regarding the IAC court. She referred to her government's willingness to work with partners in the fight against corruption and said that the UK government would engage in the discussion to establish the International Anti-Corruption Court. In Africa, apart from Nigeria, there's strong interest from the governments in Gambia, the Democratic Republic of the Congo, Rwanda, Senegal, Zambia, and Cote d'Ivoire. It is crucial to our endeavour that there should be strong support from non-Western nations and especially from Africa. If the International Anti-Corruption Court is in fact or perception a Western institution, it will be bound to fail. We know well the criticisms that came from many African states and the African Union against the ICC because of such a perception. This is the lesson which III is taking very seriously. It is of the utmost importance, I would suggest, that South Africa should play a leading role in establishing the IAC court. In the late 1990s, it played an effective role in respect to the International Criminal Court and in garnering support, and especially in Africa, for ratification of the Rome Statute. I would respectfully suggest that Professor Cachalia and his colleagues in NACAC should give careful consideration to the advantages that the IAC court could bring to South Africa and other states on our continent. Thank you very much for your attention.
It was a very succinct, but also quite a very informative overview of the proposed International Anti-Corruption Court, and also very important remarks on the role that so-called regional powers may play in terms of, curbing corruption in our region, in the Southern Africa, or even Africa in particular, how South Africa can be a very important part, can play a very important role in fighting corruption. So with that, I would then invite Professor Cachalia to at least maybe briefly discuss or share with us and the audience the extent to which South Africa has so far taken to address corruption, and if there are any international mechanisms or processes that South Africa has engaged or is looking forward to engage to fight corruption of lately. Prof, you have 15 minutes. Yeah.
Thank you very much, Professor. Perhaps I should, by way of clarification, just indicate that when Chris invited me to participate as the chair of the National Anti-Corruption Council, I agreed to do so on the basis that I would discuss the recommendations that the Council has made in our interim report concerning the restructuring of our domestic anti-corruption institutions and the establishment of a new institution. The Council's mandate is to advise the President on the implementation of the National Anti-Corruption strategy adopted by the Cabinet 2 or 3 years ago, called the All Government, All Society approach, as well as to advise him on the implementation of the recommendations of the Zondo Commission. Nevertheless, I think that the presentation, the information I was going to share, complements what has been presented in the previous two presentations. I have to say that I am certainly, in my personal capacity, having listened to Justice Goldstone, persuaded that there is a need for such a court and that South Africa can play an important role in bringing that idea to fruition, because the case is a compelling one. It does speak to the complexity of the challenge of responding to the forms of corruption being experienced in national jurisdictions and the limitations of our national institutions. I suggest that we think about the challenge of anti-corruption reform in national jurisdictions in the light of what we've heard about the transnational nature, cross-border nature of forms of corruption, as well as the need for a response through the establishment of new international or bodies with international jurisdiction. So what I'm going to do is briefly, by way of background, explain the origins and mandate of the National Anti-Corruption Council, and then share with you the recommendations contained in our interim report. That interim report has been submitted to the President. It has not yet been published, but has been considered by the Forum of Directors Generals. The next step will be for the Criminal Justice Cluster to consider the report. I can say it has been well received thus far, and that the goal is to have our recommendations considered by Cabinet, and we are hoping that Cabinet will authorize all the steps that are necessary, including legislation and budgetary provision and so forth, to implement our proposals as soon as possible, because successful anti-corruption reform in a country like South Africa requires that we act expeditiously. Time is really of the essence, because we have an accountability deficit, but I would also suggest that we have forms of corruption which can only deepen if they're not responded to effectively and comprehensively. Now, as I indicated, we've been appointed, we have 7 members, mostly from civil society, many of whom have participated in the process of consultation that preceded the adoption of this strategy by Cabinet, appointed to advise the President on the implementation of this all government, all society approach. Our terms of reference also include advising the President on the recommendations of the Zondo Commission. Now, much of the public attention on the Zondo Commission's recommendations have focused on the referral of several cases, high-profile cases, to the prosecuting authorities for further investigation where necessary and criminal prosecution. But the Zondo Commission also made several comprehensive, wide-ranging recommendations for institutional anti-corruption reform, which included appointments to and reform of the public service, party funding, electoral reform, the establishment of new institutions concerning the regulation of procurement and dealing with procurement corruption, whistleblowing, as well as a proposal to establish a permanent body to investigate corruption. So I would suggest that we need our anti-corruption efforts now should focus on both on strengthening the criminal justice system as well as on beyond the criminal law paradigm, if you like, on a broader systemic approach to anti-corruption reform. The council has made recommendations to the president in the form of advisories on procurement, on whistleblowing, on party funding, and our interim report, or midterm report rather, makes a specific recommendation to establish a new institution called the OPI, the Organization of Public Integrity, to focus on what we call systemic corruption, which is an institution aimed at dismantling and what we call systemic corruption. It should be read together with proposals to be made to focus on the criminal justice cluster, on which we have had some focus, but it's not been our primary focus to date. That is going to be phase 2. So I'm going to go through the recommendations, there are about 15 or 16 very quickly, so that there's as much time as possible for questions and discussion. The overarching recommendation is for the establishment of a new anti-corruption agency, the Office of Public Integrity and Anti-Corruption, focused on the prevention and investigation of systemic corruption. The mandate of the OPI is distinct from that of the existing law enforcement agencies, that is the ID, the DPCI, and the MPA. We define systemic corruption as follows. Systemic corruption does not always involve individual acts and is not necessarily punishable through the criminal law. It enables corruption actions. It is usually unethical, but not always criminal. It often involves hidden networks of public and private actors that distort and capture democratic and regulatory processes to facilitate the abuse of public authority for their own personal and political advantage. These networks are governed by unwritten rules and held in practice by rewards or punishments. Systemic corruption has eroded the value systems of democratic institutions, turning their purposes from public service to personal gain. One very interesting example is the VBS example, and I encourage you, those of you who are listening, to read the affidavit filed by the CEO, in which he is very explicit about these, the way in which they set up these, what we would call these systemic corruption networks. Recommendation 2 is that South Africa retain its multi-institutional architecture in its fight against corruption, rather than consolidating all the work and powers in a single commission or other institution. And I can explain why that is the case if there's an appetite for that discussion. But it goes to the idea of an all government, all society approach. Thirdly, the Council recommends that the OPI have statutory authority and the resources to create an organization and to employ staff with expertise in particular areas. It should become clear in the process of making this presentation that we are proposing to build on and augment the existing institutional infrastructure available to the SIU. It has a governing legal framework which is inadequate for the purposes that we now intend. It has an infrastructure across the country. It has some basic skills and so forth, and has achieved some significant success within the terms of its mandate in recent years. We can also discuss that question. We recommend that the Cabinet advance legislation to establish an Office of Public Integrity and Anti-Corruption as a new permanent independent institution in terms of Chapter 9 of the Constitution. That doesn't preclude other initiatives. Next, we further recommend that in the transitional phase, the OPI absorbs the mission powers and resources of the Special Investigations Unit, maintaining its full portfolio of work, thus enabling the OPI to be operational with immediate effect and adding to its functions, powers, staff, and resources. Now, this is a practical, concrete way of responding to the challenge of anti-corruption reform. We haven't simply borrowed from international experiences, although we've tried to learn from Hong Kong, Kenya, and other examples. But we've looked at what currently exists, the institutional matrix in South Africa. We've looked at our available resources. We've looked at the urgency of establishing a new institution and the time it usually takes to establish such institutions and the risks associated with doing so. I can tell you that it's taken Australia, for instance, more than 15 years to establish a similar institution, and I understand that they're beginning to have some difficulties in the implementation phase. So it's very important, if we're thinking about anti-corruption reform, to think about how we can do so successfully in South Africa as a long-term endeavor. Because the remedies for corruption, there are no quick fixes. There are many examples of success, but also of failure of other anti-corruption reforms in other jurisdictions. Next, the Council recommends that the Office of Public Integrity and Anti-Corruption should have the power to conduct investigations into systemic corruption as opposed to after-the-fact criminal prosecutions, either through a presidential proclamation, which is the current situation. The SIU can only investigate having been authorized by a presidential proclamation, but we're now proposing that it should have, in addition, a mandate to initiate such systemic investigations through new enabling legislation. So to give you some examples of what we have in mind, it should be able to go into a Tembisa hospital, or to a local authority, or to a government department, provided the prima facie conditions, if you like, the jurisdictional facts that are required to precipitate its powers. It should be able to go into any institution with full powers of search and seizure, full powers of investigation to conduct audits, including audits into procurement systems, and then to do two things. If they're to make recommendations for corrective action of systemic kind, and to that extent its powers may, if you like, overlap with those of the Auditor General and the Public Service Commission, but to make binding recommendations, and it might for that purpose, for instance, work with the PSC and with the Auditor General, possibly even with the Reserve Bank and SARS, for instance. And then if it discovers evidence of criminal malfeasance by individuals, such as, for example, the Zondo Commission did in exercising, in conducting its inquiries, we are proposing that this body should have powers of criminal investigation. In other words, to carry out the investigation, to compile a docket, and then to submit that docket to the MPA. which will shorten the period of investigation and prosecution. For this purpose, it will obviously require the appropriate skills, both to make recommendations of corrective action, as well as to conduct criminal investigations, and to work under the supervision of the MPA. It should be noticed that this proposal, while it expands the powers, because the SIU doesn't currently have these powers, doesn't withdraw any powers of criminal investigation from other existing institutions of law enforcement like the DPCI, and therefore should not be opposed by the DPCI, but augments the country's existing powers of investigation. Next, the Council recommends that the OPI be granted additional powers to convene public hearings into instances of systemic corruption, to compel the attendance of witnesses at those hearings, and to require the production of documents and other physical and digital evidence in conjunction with those hearings. Now, those of you who have been following the recommendations of the Zondo Commission will have noticed that this is an attempt to respond to the recommendations of the Zondo Commission, because these powers of inquiry are the ones that the Zondo Commission recommended, and it also responds to the Zondo Commission's recommendations to establish a new institution to focus on procurement corruption. But of course, we haven't accepted the recommendation fully, because we think that we should avoid a proliferation of complementary institutions, if you like, when we're thinking about effective institutional reform. Next, the Council proposes a prosecutor-led investigation system in collaboration with the OPI investigative system to prosecute criminal conduct exposed through investigations of systemic corruption, which is a repetition of a point I've made earlier, but it really builds on the steps that have already been taken through an amendment of legislation to reestablish the prosecutor-led model of prosecution and investigation through the IDAC. Next, the National Council also recommends that the investigators employed by the OPI be granted search and seizure powers to prepare and fully investigate any potential criminal conduct that is discovered during the course of a systemic investigation. The OPI needs to be given powers to prepare criminal dockets for presentation to the MPA. That's some repetition. Next, the Council recommends that the OPI should have a mandate in its civil mandate processes to claim damages or utilize other civil recovery mechanisms. This should be expanded to include asset recovery arising from criminal investigations. That would also be an addition to existing powers. Next, the Council recommends that there be a legislative amendment to enable the Special Tribunal to have powers of criminal forfeiture, such powers only to be exercised by the OPI in collaboration with the MPA Asset Forfeiture Unit and subject to the provisions of the Prevention of Organized Crime Act. Next, excuse me, the OPI is to meet the established rigorous tests for the independence of the any anti-corruption institution in terms of the so-called STIRS criteria, now constitutionalized as a result of the Glenister judgments with respect, for instance, to insulating the new body from political influence through appointments, budget allocations, security of tenure of staff and of its head and so forth. And that's why we've recommended that the new body should have Chapter 9 protections. And finally, the Council recommends the appointment that the appointment of the head of the OPI be the accounting officer who must meet specified statutory criteria of eligibility and qualifications. Finally, the Council recommends that the statute must give the OPI the mandate to drive the long-term rollout of the National Anti-Corruption Strategy and advise the government on policy measures to advance the NACS, the National Anti-Corruption Strategy, educate and mobilize the public to gather and analyze relevant data to corruption and anti-corruption, and to monitor and evaluate the impact of measures designed to prevent corruption, including the receipt and analysis of materials classified as restricted, confidential, or secret. You will have noticed that no institution in our current institutional matrix carries out this role. And so we've identified a gap. Policy making through proper data, ongoing data analysis, and then monitoring and evaluation. There are parts of the system, even the Department of Education, for instance, that have some complementary roles, but there isn't a department in the state that currently ensures that corruption reform remains permanently on our country's agenda. Council also recommends...
Excuse me, Professor, excuse me.
I'm almost done.
Thank you.
The Council also recommends the establishment of conflict resolution mechanisms to deal with problems that arise when more than one institution is investigating a particular case. So obviously coordination and collaboration is something that's going to need attention. And then finally, the Council recommends strengthening the efficiency and effectiveness of the National Prosecuting Authority's coordination and collaboration role in a multi-agency anti-corruption criminal justice framework and system. May I just say finally that we, in our next, in phase 2 of our work, so it's a midterm report, we are focusing on the implementation of the recommendations of the OPI. And secondly, we've established a working group to look specifically at the criminal justice system, headed by Dave Lewis, which will include looking at the financial architecture. Thank you very much.
Thank you, Professor. Sorry, I really had to interrupt you, especially when someone is talking about corruption. It feels like really I'm cutting one organ of my own body, because I really want us to talk about this very interesting.
No problem. Thanks a lot for the time.
But, in the interest of time, I'll just go straight into the question and answer segment. I do see that we have a couple of questions in the chat box, but I also do have some of my own. Maybe we just begin with that, and then we can also come back to our viewers. The first question is, of course, to Michael. Michael, you presented quite very interesting, hard evidence of corruption, transnational corruption, but also other, parties based in countries where the fight against corruption is quite genuine. Some of these multinational corporations that are involved in paying bribes to senior public officials and politicians in South Africa are based in countries where mechanisms at least are in place to fight corruption. Have you shared any of this information, any of this evidence with some of these, with relevant authorities in those countries? And likewise, have you also shared some of the information or evidence that you come across with others, other authorities in other states that are lowly governed or don't seem to have a high appetite in prosecuting grant level corruption? So this is for you, Mike. Also a related question, Richard, the role of non-state actors. We have seen that, especially in African countries, that non-state actors, some of them are big enough, to an extent that they can frustrate any meaningful processes to get senior politicians or public officials to account for their illicit activities. if without mentioning names, I know a certain country, in a certain African country, where being the head of certain multinational corporation is like the most second important position in that country. So what are you doing as, those who are working with I and also pushing forward the agenda for the International Anti-Corruption Court to engage non-state actors, especially those powerful non-state actors, some of them with records of paying huge bribes to developing states officials? And then finally, my question to Professor Cachalia is, these are recommendations. How do we make sure that they are not just a wish list? What mechanisms do you have in place for their implementation? Just a quick on this round, and then we get back and I'll read some of the questions that are in the chat from our audience.
Thanks very much, Prof. I'm happy to go first to restart the order. I think it's a fairly brief answer, which is that yes, so Open Secrets and partners in civil society have compiled. We've done our best to compile examples of criminal dockets, for example, to hand over to the National Prosecuting Authority in South Africa. But we also, in several instances, have provided information and correspondence to law enforcement agencies based elsewhere. In the United Kingdom, for example, others in civil society have provided information to American authorities as another example. And the reality is the outcomes of those have been mixed, but have largely been disappointing. And I think that it's a reflection of a few different things. The one is that, as Justice Goldstone has mentioned, and Professor Maguchu, you said this as well, there are lots of countries that have formal mechanisms to investigate corruption, but many of those are also very high up on the Financial Secrecy Index. And so countries that perform well on the Corruption Perceptions Index often perform very poorly on the Financial Secrecy Index. And I think we have to admit the fact that one of the challenges of dealing with international and transnational corruption is that many of the corporate actors involved are very powerful domestic actors. And so there isn't always necessarily the appetite in those states to hold their own very large corporations accountable for their conduct elsewhere. And so that I think is an ongoing struggle. And there is an unevenness in the way that those matters are dealt with. And the other thing, of course, that I would say in that regard, and listening to Prof Cachalia speak about the proposed powers for the Organization of Public Integrity, is that as a civil society organization like Open Secrets, we are always one step behind, because we don't, of course, have the investigative powers of law enforcement. And it really returns us to this notion that if you want to properly address this type of grand corruption, and illicit financial flows, you have to have effectively empowered institutions of state with proper search and seizure powers, asset seizure powers. And so the work of investigative journalists in civil society in identifying and uncovering corruption is absolutely crucial. But we have struggled ultimately to transfer that into action. And that's often been because of the kind of slow nature of action on the part of formal authorities.
Can I go ahead?
Yeah. Yes. Sure.
Yeah. So the proposal is not a set of discrete, unrelated recommendations. The recommendations add up into a coherent proposal. At least we think it does. The proposal is the result of extensive consultations with all the law enforcement agencies, the DPCI, the SIU, the ID, the MPA, other bodies like the Reserve Bank, SARS, the Zondo Commission, the Fusion Center, the FIC, the Treasury, the Department of Justice. And we, for that reason, are confident that we bottom up, accumulated the kind of information and insights we needed in order to design a specifically a South African response, given knowledge of our own context, if you like. Secondly, because we are a council set up to advise the president, we are on the one hand both independent, so we've been given, we have the space to to take an independent view. We are not in that sense part of government, but as we're advising the president, we're also well placed to engage, if you like, within the governmental system. As I indicated in my report, we've already made a presentation. So the presidency is aware of our proposal. We've discussed our proposal in a forum which brings all the directors general together from all the departments, including the law enforcement agencies. We were very well received in that forum. The next step is to go to the criminal justice cluster, where we will be engaging more closely with the Department of Justice. And by the way, we've worked very closely with the Department of Justice in other areas, for instance, whistleblowing. One of our councillors, Tandeka Ngubule Mbeki, in fact, participated in the process leading up to the recommendations, the Department of Justice's recommendations with respect to whistleblowing. I've indicated that we've set up a working group to consider implementation. So this is not just a set of proposals. We're looking at legislation. We're looking at organizational design. We're looking at the kind of skills that are going to be required. And we are hoping that this proposal will get to the cabinet as soon as possible through the normal cabinet processes. And that by the end of our term, which is, in about the next year, we will have legislation. Now, that's an ambitious target, but that's what we are hoping to achieve.
Thank you, Prof. And Richard, quickly, if you still remember on actors, idea of an international anti-corruption code, then I'll quickly go through the questions that we have in the chat.
Thank you. Well, I wonder if I could deal with the three questions which have been put, which seem to me to relate to the International Anti-Corruption Court. With your permission, Professor.
Yes, please, sure.
Yeah, the first one, as I understand it, relates to protection of whistleblowers. It doesn't refer to whistleblowers specifically, but it talks about protection of people who spill the beans. This is obviously a crucial and a very difficult question, and one on which one can't generalize. I was personally involved with protection of witnesses in the Yugoslavia, in the UN tribunal for the former Yugoslavia, but also, and perhaps more importantly, in relation to the Commission on political intimidation that I headed during our transitional years, and in fact, the answer that the route we had to take in the case of the South African Commission was to get whistleblowers out of the country to protect their lives and sometimes their family as well. Norway played and the UK played important roles in giving a serious protection to some of the whistleblowers, and they stayed out of the country for some months, in fact, until after we became a democracy in 1994. In the case of the Yugoslavia tribunal, we had to get witnesses out of Bosnia, and again, Scandinavian countries played an important role in giving protection. So those are some of the extreme measures that have to be taken, but obviously they have to be, where possible, in a country where the government and police cooperate and the prosecution authorities cooperate. One would be able to arrange for a protection domestically within the country. But this is a difficult issue, and as I say, one has to look at each situation and each country separately. They all have their own peculiar facts and circumstances that have to be taken into account. The second question relates to the African Union adding corruption and money laundering as international crimes in the Malabo Protocol. Well, obviously, this is an important development. I think it recognized what I referred to during my main remark, to the fact that these crimes of corruption, money laundering have become internationalized. And the AU has added to that recognition by including them in the Malabo Protocol. Having said that, the prospects of the Malabo Protocol coming into operation in the foreseeable future is almost zero. It requires 15 ratifications to come into force. So far, there's been one, and the one has been Angola earlier this year. It's true there have been 15 African nations have signed the protocol, but only one has ratified. So it's really talk at the moment rather than implementation. And it's not surprising, it seems to me, that Angola has recently ratified, having regard to the billions of dollars or billions of British pounds, probably trillions of South African rands that were laundered during the over 30 years of the rule of President Dos Santos and the shenanigans of his daughter Isabel. So I wasn't surprised to see Angola ratify the Malabo Protocol. The third question is a difficult one, relates to the capabilities of Middle Eastern countries to cooperate with an international anti-corruption court. And again, I don't think one can generalize and really talk about regions as if they had something all in common. It's true that the Middle East as a region has not been particularly active with regard to international courts, and particularly international criminal courts. And it does depend on individuals to a great extent. I know he won't mind my mentioning, but I would refer to the tremendous contributions that were made by Jordan's Prince Zayed bin Riyad. Obviously, we all know he was the UN High Commissioner for Human Rights, where he played a crucial role. But he also spent a period as the president of the Assembly of States Parties of the International Criminal Court. So one can't generalize. I think it's very important that all regions should be actively involved, and that's why I stressed in my original remarks that it's very important for Africa to be involved and for an international anti-corruption court not to be seen as a Western institution. The more representative it is of all the regions of the world, the more likely it is to succeed. Thank you.
Thank you so much. Thank you so much, Dr. Taye, Dr. Materu, and also Mr. Mehdi for your questions. I don't see any other questions from our viewers, so I can just give an opportunity, just maybe half a minute, to each of our presenters. If you have any last remarks, any remarks, final remarks on this very important, crucial topic, how to harness international mechanisms to fight corruption in the region and probably also across the world. Just half a minute to a minute, your final remarks, our take-home point, what you want us to take home with us after this discussion. Maybe I can start this time with, Michael, you are ready. Please go ahead.
Thanks so much, Prof. And thanks very much, I think, to everyone for what was an incredibly interesting conversation. And I certainly learned a lot, I think, about the processes that are happening in South Africa and outside. I think in terms of a takeaway, there's so much that we agree on that I won't repeat, that I think has come up. I think the takeaway for me, something that I'm going to continue to grapple with, is the difficulty of holding enablers, professional enablers, to account for their role in corruption. And I think, Justice Goldstone was making this point that so much corruption law has been internationalized and is as well established around bribery and a whole range of those things. I think that the one area where we're probably further behind is in properly regulating the role of certain professions that have been under-regulated in the past, especially outside the road of bigger banks and others. And I think from our side, that continues to be a big challenge, and it will continue to be a challenge for both domestic and international mechanisms to kind of properly capture those very important actors in their nets.
Richard?
Well, I would make one point, and that is South Africa in recent years has become more and more involved in using international law. And in that context, I would really expect that our government would take an interest in an international anti-corruption court and to recognize the importance for Africa of such a court, and to join with the other governments who have already come on board, including Nigeria, that South Africa will join that group of countries in helping to establish the court in the near future. Thank you.
And finally, Prof. Cachalia, your final remarks.
Thank you, Prof. Well, having listened to Michael and Justice Goldstone, which I was challenged by both presentations. I think that this interface between enforcement, the challenge of improving enforcement and accountability in national jurisdictions, the interface with the global and international is challenging, because it suggests to me that we should rethink in the Council the scope of our mandate. If these two, in a sense, are inseparable, if the challenge of fighting corruption and improving accountability in national jurisdictions is inextricably linked with the global, then the work that Justice Goldstone is doing perhaps falls within, is a matter that we should be considering. And perhaps we'll extend an invitation to Justice Goldstone to engage with the Council. And similarly to Michael, I think Open Secrets is doing fantastic work. I think you've brought insights to this conversation, which is generally not part of the current conversation. Very important, the role of enablers, the whole international dimension, money laundering through the financial architecture and so forth. And I'm certainly going to ensure that there is engagement between the Council and yourselves, to the extent that we can support your work, and you can provide us with insights which are important for the work that we're trying to do. So thanks very much, and thanks to the Helen Suzman Foundation for setting this up.
Yeah.
Well, then maybe on that note, Prof. Maguchu, I can just take over and just extend an incredibly sincere thanks to all of our speakers today. I think we were treated to a wonderful discussion that I think was not only enriching in and of itself, but I think Prof. Cachalia really summed it up at the end there, that this dialogue is definitely going to continue into the future, I think, in some very constructive collaborations. And I think that's precisely what we want out of organizing platforms and spaces like this. So thank you to all of our speakers, and thank you to the HSF team who made this possible in terms of the design, invites, admin, research, all of that. That's Sophie, Ezekiel, and Luke who are listening. Thank you very much. And I guess with that, we can close this. We can close the webinar. Thank you very much.
Bye all.